First off, thanks for inviting me for the excellent dinner last night and the great conversation. And it's all been a lot of fun. So, cool. So I guess what I'm going to talk about a little bit today is objectively evaluating legal briefs, lawyers, and law firms. The work here, everything you're going to see is predicated or built on top of about 5 years of development using humans and machines to map out California law. So the sort of like unseen hero of this is all the effort to understand and map out what actually is happening in case law and statutes, and then build technology on top of that. So very simple. We take in a brief, so filing in court. This is all in California State Court. And then we give it a grade. And the grade sort of conveys two things. One is our assessment of the quality of what's in there, and two, our assessment of the likelihood of the brief winning. And those are kind of two slightly at odds concepts. So you can have a high quality brief that is low chance of winning. You can have a low quality brief that's high chance of winning, and the score kind of fudges the two. And so that's something that people have to keep in mind with this software. We're measuring two different things. And I'll get into that a little bit later. And I guess the other thing is that we kind of graded it on a US grade school approach just because we thought that had a little bit more punch. So, it gets people's reactions. That grade is, for some of the discussion today we have about quality and how do you measure various things. We broke it down across 3 large dimensions, arguments, drafting, and context, and each of those are subdivided, and we're kind of evaluating concrete components of those. And so what I'll do is talk about each of those in turn, but each of the arguments, the drafting, the context gets some score associated with it, and then those are rolled up into an overall grade. So on the drafting, these are the most basic elements. These are sort of the legal equivalents of dotting I's and crossing T's. We evaluate the citations. Are the citations free of errors? Pretty basic. It's easy to tell if they're correct or not. Quotations are is a text that's quoted from a case or a statute correct? Has it been modified? And then what we call supports, which is for a given legal principle, are the legal principles supported with strong or appropriate precedent? And across each of these dimensions, the higher scoring a brief does, the more likely it is to win. That's kind of one of the key things that we kind of built this as, and we found was that each of these dimensions were correlated with positive outcomes. So you do a better job, you are more likely to win. That does not mean you will win, but your odds go up. So citations, these are briefs that came out of an analysis of the 20 largest law firms in California. Most of the examples are like that. So we see, for example, on the right, we've got the correct citations. On the left, we've got what's in the brief. On the left, they misspelled Quelimane, which is the #1 case on demur in California. Kind of, it's minor, but we see that stuff happening. So we check for, the spellings. We check to make sure that your volume numbers are correct. On the right, there's a 29. On the left, a 63. That you cite to the correct reporters. This one, they dropped 3D. Sometimes they'll just put in a different reporter. That you cite to the year correctly. So really basic stuff, but obviously, if you're sloppier on this, you're probably not having as much attention to detail, so you may not be doing as well on other things. The thing is, this is not just the lawyers who are making these types of mistakes. The judges do as well. So this is from a California Supreme Court case. It's been cited 1,100 times. It's one of the most heavily cited cases in California. And they're citing to Cotati, but they have this 124 Cal Reporter site, which is from Equilon. And this matters because when you have cases or when you have documents and they have citations that are formatted with names and numbers, if you want to have software that automatically is figuring out what's there, building a citator on it, or linking it from a brief, or you upload a brief and you want to pull out the treatments, the Shepard's type stuff, it needs to be correct and it needs to be in a format that software can read. And so when you have inconsistencies like munging of 2 different citations, that causes a big problem. So we've had to do a lot of work to handle those variations, but there are some situations where the sites are so garbled we can't actually figure it out. If we're lucky, there's a quotation and you can go check the text. So quotations. This is one of the things that got a little more attention when we initially announced or launched the quotation checking within our software. Turns out lawyers misquote the text a lot of cases and statutes, and some of the times it looks kind of peculiar, and a lot of times it's meaningful. Not the majority of the time, but there are significant things. For example, we see on the right, and became an or in the brief. On the right, there was a qualifier that's reasonable. On the left, it's not there. So those are both total misquotes. The third one's kind of a fun one, which is it's a modification of the quote. They actually do put in brackets ice cream, but this is a quote about the conditions in the film industry, and they just decided to, rather than say ice cream industry is similar to the film industry, they just decided to put it in brackets as if the original case was about ice cream, which it was not. So this is, the courts do notice this. This is a quote from California case. Counsel would be well advised to not misquote cases to this or any other court in the future. They see this, there are court rules about it, and yet pretty much every single brief that we analyzed in our law firm evaluation of California large law firms had misquotes. Supports. So this is where we start to move a little bit away from like the very obvious, clear drafting types of errors. One of the first things that I was taught as a lawyer was when I'm writing a memo or a brief, if I'm citing to a legal principle, cite to a case that goes my way, and you want something that's on point. And so one of the things we do is we look for legal principles that are in briefs, and then we figure out what case you're citing to and check if there's potentially a better case. And a better case might be one where your side wins as opposed to the opposite side. And you see that a lot in case law where the judge is saying, plaintiff relies on case X. Case X actually supports the defendant because the facts there were the defendant won. That happens a lot. So we look for that. And here is a brief where there's a citation to Barkey, which is a seminal case on this legal principle. A lot of cases cite to it for that. It's the same cause of action, but it's the wrong posture, so it's not quite as on point. And I forget if this one has the right outcome. But Bank of the West does have the desired outcome in terms of the winning party, so that's potentially a better citation, or at least a parallel citation or a string cite that you can add. And just to reemphasize, briefs that do better on this dimension, again, do better for overall outcomes, and that'll start to make sense, I think, as we get to the next piece here, which is with arguments. What we're looking for are basically how strong are the arguments you present, how much do they favor you, how well do you present them. So we have what we call cases sharing arguments, which looks at how favorable are the arguments and the legal principles to the author of the brief. Are you generally citing or relying on arguments that will indicate that you should win? What are the vulnerability of the cited cases? So how likely it is that the precedent you are following or you're citing to will be followed or will be ignored or distinguished. And then the third is a little bit more fuzzy, which is the outcomes of cited cases. How balanced is the discussion of case precedent? And I'll kind of talk about each of those. So cases sharing arguments, just as in with the last supports, we have a legal principle, and we showed you potentially what's a better case to cite to. Here what we do is we take all the legal principles in the case, in the brief, we figure out cases that are applying that legal principle, collect that mass of cases, and then figure out across everything who should be winning, the plaintiff's winning or the defendant's winning. And we end up with a pie chart where you can see all the cases that are implicated by the various legal principles, and then you can say, do they support my side or do they not? So the arguments on the left here, the plaintiff is the dark blue top left, and the defendant is the bottom right. Defendant's about 1.5 times more likely to win than the plaintiff on this set of arguments. So if you just kind of said, pick a case, and that outcome is what decides. Defendants are more likely to win. On the right, the plaintiff is 2 times more likely to win. And in fact, these scores are from 2 different briefs in the same litigation. The weak one was a demur on the original complaint. It lost. The second one was the opposition to the demur, and it lost. The second was the opposition to the demurrer to the first amended complaint. So after they had amended complaint, and it won. And you can see that the arguments look more powerful. Is that a coincidence? Who knows? What we do tend to see, though, is that the more strong or the more favorable the arguments are towards you, the more likely you are to win, which makes sense at a basic level. If you're citing cases that show the defendant's winning a lot or the plaintiff's winning a lot, the judges and the clerks are going to be kind of impacted by their sense of what the law overwhelmingly suggests. So vulnerability of cited cases. One of the things that we did with Judicata was we built our own citator similar to Shepard's or KeyCite, but we focused on making sure it was extremely accurate, more comprehensive than the other ones, which allowed us to go past just having a flag, identifying if a case has been distinguished or overruled, that kind of treatment, and actually say what's the probability that a case will be followed or distinguished. And we call that vulnerability. So, Brinker is being heavily relied upon here in this brief, and it's low vulnerability, which means most likely it's going to be followed. Same with Daly. However, Jaimez is high vulnerability. A lot of cases are distinguishing it or saying it's been superseded, we're not following it on that point. And then Falconbury is moderate. So at a basic level, it kind of makes sense that if you're relying on cases that have been distinguished a lot, probabilistically, you're less likely to win. Now, a common sort of refrain is, well, sometimes you have to rely on cases that are less vulnerable or more vulnerable. Yes?
And so the treatment for the caution, what does that mean?
So caution, we've bucketed our treatments into sort of red treatments, orange treatments, and blue and green treatments. And so the caution is sort of a collection of distinguished, not apply, which is sort of similar, contrasted, that kind of stuff. And you could click through and see the citator and see each case, how it's treated. So we end up here with a sort of measure of whether the cases are likely to be followed or distinguished. And the key is that, if you're relying very heavily, a high proportion of your cases, so not the absolute number, but a high proportion of your cases are vulnerable to being distinguished, your chances of winning drop a lot. So on the left, we have, for example, a third of the cases have an elevated vulnerability. On the right, none of the cases have elevated vulnerability. But that's done as a measure of percentage. And so you'll often see, a brief has 2 or 3 higher vulnerability cases, but they have a lot of other precedent that they're relying on that is solid. Okay, outcomes of cited cases. One of the things we know about each of the cases in California is who's winning and who's losing, whether it's the plaintiff or the defendant. And we can look at the briefs. We pull out for each of the cases the citations. We know who's winning, and we kind of break the cases up into plaintiff winning cases and defendant winning cases. And one of the things that is important is to make sure that you both are presenting your side adequately, but also attacking the other side. And there's some sort of balance around how you want to do this. At the extremes, you have here on the left, so this is from a defendant's brief. A majority of the cases they're relying on, let me rephrase it, they're discussing are plaintiff winning. So they're not presenting a lot of cases where the defendant won. So while they should be showing a lot of precedent that goes their way, which makes it look like their side is more powerful, here they're actually not doing that. Whereas on the right, we've got defendants are citing a lot more defendant winning briefs, which is messaging to the court, the weight of authority goes my direction. Again, this is one of these things that the better you score, the more likely you are to win. Context, I'm not going to jump into any real detail just for interest of time, but what we're looking at here are a measure of similar cases, cases that arise in the same causes of action, same procedural posture, same side, plaintiff or defendant, who tends to win. So we come up with a sort of statistical measure of how likely you are to win just based on other similar cases. And judges, same sort of thing. We look at a judge and we figure out how likely they are to rule for one side or the other. And across both of these, we have a rough measure of how likely a party's brief is to win based on content or data that's not in the brief. If we just kind of took a blank slate and said, how likely are you to win, that's what the context measures. We end up with this report, again, has the grades, something like showed before. And the context and the arguments, this is where it gets a little bit more interesting. Arguments measures how likely the brief is to win based on the arguments in the brief, the cases relied upon and attacked, and the balance of the argumentation. So you can kind of look at that as a rough statistical measure of odds of winning. Context measures the likelihood that the brief is to win based on just generic information, causes of action, procedural posture, and the judge. So context is nothing about the brief. The arguments is kind of everything about the brief. You can actually look at the difference between the argument score and the context score. And if the argument score is substantially higher than the context score, that means that the arguments suggest the brief is more likely to win than you would think from the context. If the arguments is substantially lower than the context score, it means that the arguments look a lot weaker than the context suggests. So we call that overperforming and underperforming. And one of the things that we found is that strongly overperforming briefs have a higher chance of winning. Strongly underperforming briefs have a higher chance of losing. So these measures, while they're sort of general, simple statistical measures, they do correlate with real-world outcomes. So evaluating law firms. We ended up taking a bunch of briefs from the 20 largest law firms in California, scored them, took all the briefs from each of the firms and kind of calculated their average score, and then we ranked them based on those scores. And a few things that came out that were kind of interesting. One, lower firm ranked in our analysis, the more likely they were to have strongly underperformed, what we saw in the last slides. And also, the lower firm ranked in our analysis, the more likely they were to have strongly underperformed and lost on that, which suggests some sort of relationship between the quality of the brief and some measure or some word and what the impact is for the clients. We also had a surprise discovery, which was that a lot of the firms misspelled the judges' names on their briefs. Actually, 9 of the 20 firms, 45%, including one represented here today. But they're in good company. The lawsuit of the year, right here, everyone knows this one, Stormy Daniels. They had filed a 170.6 petition to get the judge removed, and they misspelled the judge's initial. It was not it's an R, it's not a J. So it's common. That's all I have. Thank you.